So here we have, hey everyone, so here is Rule 608. It deals about character evidence, not typically as it would under Rule 404, but when it deals with the specific trait of character of truthfulness or untruthfulness. Namely, character about whether someone is a truth teller or a liar is able to be admitted and propensity is able to be used unlike any other trait of character. Partly that's because of the just general importance of it, the general importance of whether someone's telling the truth or not when it comes to like determining cases, but also part of it is because the law has kind of, perhaps wrongly so, concluded that once a liar, always a liar. Regardless, that's how the law is, and here's how it's going to be relevant to you. First, I'm just going to read the rule, and like, there's not a lot that it's good to know that. If you're trying to bring out prior evidence that someone's a liar, not that I think that exists in this case, then you can do that. But I'm going to talk specifically about how it's complicated by the restrictions of mock trial. But first, let's read it. So this is a witness's character for truthfulness or untruthfulness. Reputation or opinion evidence. A witness's credibility may be attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. But evidence of truthful character is admissible only after the witness's character for truthfulness has been attacked. This line right here is the basis of an objection called bolstering. Namely, if someone's credibility is getting bolstered before it was ever attacked, then that's not okay. Essentially, you can't just come up and say this person's a great person unless the other side has some plans to attack that person's credibility. This applies very directly to truthfulness or untruthfulness, and this is where you would cite an improper bolstering objection specifically to that trait of character. But bolstering has kind of been extrapolated to apply to almost all character traits. So if they're offering positive character evidence and you have no intention of attacking it, then you can say improper bolstering. Now, let me be very clear about how this relates to mock trial, and hopefully this follows. It's less understandable and more abstract in this year's case than in most, because in this year's but there's something called a character evidence form that in mock trial you have to sign, essentially giving the other side prior notice of whether you're going to be eliciting positive or negative character evidence of truthfulness of either the victim or a defendant in a criminal case. And the reason you have to do this form, you wouldn't do it in real life, is because in real life the plaintiff has their case, then the defense has their case, and the plaintiff can call rebuttal witnesses after the defense's case, the purpose of those rebuttal witnesses being to bolster the character of witnesses that testified prior that the defense decided to attack. In real life, you don't know whether the defense is going to attack credibility of a witness or not, and you're not allowed to bolster the credibility beforehand, so you have to do it at the end. In mock trial, you obviously can't call witnesses after they've already done so, because you have to have 3 on each side, et cetera, et cetera. So you have to sign a form as the defense that says, I'm going to be admitting negative character evidence of your person, so you can go ahead and bolster preemptively and in anticipation of my negative character evidence that's forthcoming. Just know that's how that goes. There's a lot of different little nuances that you can use this in arguing those objections that I won't delve into right now because they aren't directly relevant to this case, but just know that those exist and that this is where you can find them. That this entire comment talks about this character evidence form and the necessity to preempt bolstering character evidence. Secondly, 608B, specific instances of conduct. Except for a criminal conviction under Rule 609, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness's character for truthfulness. But the court may, on cross, allow them to be inquired into if they are probative of the character for truthfulness or untruthfulness of the witness or another witness whose character the witness being examined has already testified about. All this means is that you can't shit on a witness with later if that witness isn't a defendant in a criminal case or a victim in a criminal case, with other witnesses in the trial via specific instances of their bad conduct when it comes to truthfulness or untruthfulness. Like, you can't have Terry Chapin testify, then have Danny Brooks on defense come and testify later about how Terry Chapin's a lying motherfucker and how Terry Chapin doesn't pay for babysitting either, and Danny Brooks is just getting stiffed or whatever. And all of that matters because Terry is being untruthful or something. I don't know. You couldn't do that, but what you could do is you could, on cross-examination, try to get the witness to admit to confessing or not. When the term extrinsic evidence here means outside evidence, outside documents besides the witness you're questioning, who you're, I guess in this case, attacking their credibility, their personal knowledge. But so that's what they mean by extrinsic evidence, and that's 609B or 608B. We'll go into 609. There's a method of impeachment when it comes to the character for truthfulness or untruthfulness using prior evidence of a criminal conviction. We're going to talk about that in the next video. But thank you for watching. Hopefully the character evidence form stuff makes sense, and I'll see you next video.